Good afternoon, all. Good afternoon, Advocate Chauke.
Good afternoon, Chair.
Advocate Nkcukaitobi.
Thank you, Madam Chair. Madam Chair, to start with the subject we left hanging, I've asked my team to find the exchanges of that day. They have found day 39, the 6th of March 2026, at page 12.
Yes, Council.
Where the following exchange takes place. Advocate Baloy Mere, right at the beginning of the page. Advocate Mutlamunyane, can I find out these documents? You obviously found them from somewhere. Advocate Mutlamunyane, yes, from someone. Advocate Baloy Mere, from someone. Advocate Mutlamunyane, yes, from someone. Advocate Baloy Mere, and that someone will obviously come to testify on these documents. Advocate Mutlamunyane, not necessarily. Chairperson, how possible is that? It goes on and on. So the idea that they were not asked to confirm the sources seems to be contradicted by the record. So Mr. Mutlamunyane can take whatever steps he wishes to take, but the question is a legitimate one.
Let me understand the point of objection. Advocate Mutlamunyane, what is your point of objection exactly?
My point is, Madam Chair, from what Advocate Ngcukaitobi SC is suggesting, it would appear he is insinuating that I'm suppressing evidence and I'm refusing to give the source. Nowhere in this record have I refused to give a source. As evidence leaders, Madam Chair,
let's not take much time on that. We have read the transcript, and as we understand this transcript, there is nowhere, Advocate Nkcukaitobi, where Advocate Mutlamunyane was asked where he got the documents from. Is that your concern? Is that your concern?
My concern is, Madam Chair, that I never ever said I will not disclose my source. I never said that. Because the insinuation by Advocate Ngcukaitobi is that we are suppressing documents, we are suppressing evidence, and I've not disclosed my source. I've never refused to disclose my source. I went out there as evidence leaders, as an evidence leader, to try and assist this inquiry by going out and getting witnesses. Inquiry, we don't have investigators, we do it ourselves.
Yes, understand that. I don't want us to get out of the issue because we must settle it and proceed. Can we agree on this before we roll out?
Yes, we can agree on that, Madam Chair. As I say, the fact of the matter is that there was no disclosure of the source. I take it no further than that.
We will make a ruling that in the transcript there is no suggestion that Advocate Mutlamunyane had been asked to give the source of the document. I think that's how far we can take it.
Thank you, Madam Chair. I'm not taking it beyond that.
Thanks, Madam Chair.
Yes.
But I would like to go further outside this ruling that Advocate Mutlamunyane, where did you find the document? Because if you look at the transcript, from the debate we had with you and Advocate Lekgetho, following Advocate Ramokhale's objection to your handing up the documents, we had that long exchange. And Advocate Lekgetho made it clear that indeed this document, the Konko's docket, had been searched by the KZN police and the NPA, they couldn't find the document. To the extent that the station commander, KZN, prepared an affidavit that was handed to you by Advocate Lekgetho to say they cannot locate the document. Efforts were made by the NPA even to search or to inquire from iPad. So this document has not been available and has been searched for by several people, and it resurfaced that day. What we found strange, Advocate Mutlamunyane, and I don't want to repeat what we said. We were in chambers. You never disclosed to us about the disclosure that you wanted to make of that very document that came from the Tonto's docket. You had neither spoken to the Chauke's team about it, and you took all of us by surprise. Hence the objection. So we should not find ourselves spending time on issues such as this. I request all of you. We must take this panel into your confidence, both teams, and disclose documents. If I may ask you now, what is the source of that document? Where did you find it? Because everybody has been looking for it.
I'll speak for myself. In my attempt to assist the inquiry, when we consult with witnesses, I usually ask them as to whether they can provide any documents that can assist.
No, but let's get to the point. My question is very straightforward, Mr. Mutlamunyane. Where did you find the document? Because everybody is saying we have not found the document.
I'm getting there, Madam Chair.
No, but we can't spend so much time on the simple question. Where did you find it?
I was referred to an officer, Paul Mostert.
Paul Mostert?
Yes, who was one of the Katomana officers.
Yes.
And he provided these documents to me. I requested for documents that can assist me in cross-examination.
So it's Paul Mostert who gave you the document?
Yes.
Yes, thank you.
Yes.
Please proceed, Advocate.
Yes. Thank you, Madam Chair.
Ngcukaitobi.
You know, Mr. Chauke, has he been warned or has not been? Has he been warned? I don't know. Yes.
Please bear with me. I was trying to locate where we ended when this issue arose. Advocate Chauke,
Yes, Chair.
please bear with us, the panel and the advocates. You've been watching this exchange and sitting there patiently. You remain under oath.
Thank you, Chair. I confirm.
Thank you, Madam Chair. I think, Mr. Chauke, maybe you can comment on this. Your speculation was that these documents could have only come from the accused.
Yes,
Now,
indeed.
for the first time after, I think, 7 months, we are told that the Congo docket is sitting with Mr. Paul Mostert. What is your comment on that?
Very, very unfortunate. Very unfortunate that the NPA and the police stations themselves, they do not have that docket and sitting with an accused person. All
Mr.
I can say
Mostert,
is just unfortunate.
I think Mr. Mostert has 13 murder charges against him. 13 murder charges. He killed 13 people.
Yes.
And so that's the person the NPA is using, sorry, not the NPA, the evidence leaders are using in these proceedings.
I understand so.
Madam Chair, I object to that. I object to that proposition that my learned colleague is putting to the witness. We are evidence leaders who have no interest in the matter. we must be seen to be neutral, and we try our best at all material times, Madam Chair, to be neutral. We cannot be seen to be blemished in the manner in which my learned colleague is doing. The document has not been sitting with me. I asked for documents that could assist me in my cross-examination of Shamila Williams, Miss Shamila Williams. And these are the documents that I got. Now it appears my learned friend wants to suggest, it's suggestive. What he's saying is suggestive that I knew all the time where the documents were. I have no business, really.
Well, he says you are using Paul Mostert. That's what you are objecting to?
Yes, I'm not using Paul Mostert, Madam Chair. I was referred to Paul Mostert when I was consulting with Johan Boezen. And now it appears a picture is now being painted before this inquiry and before the public that we're consulting with criminals, with suspects.
Don't put words into counsels. It's better to just focus on the point that you are objecting to and not say things that you are being, a suggestion is made that you are consulting with criminals and all that. He did not say that. So let's just confine ourselves to what you are objecting to. Please.
As it pleases you, Madam Chair, I leave it at that.
Madam Chair, the person I am talking about is Paul Mostert. There are 13 murder charges against him. That is a fact. He is the source of the evidence leaders. That too is a fact. That's what I want Mr. Chauke to comment on.
I confirm that is amongst the suspects who have been arrested and were indicted to appear in the High Court.
Yes, but on 13 murder charges, killed 13 people.
Yes.
Yes. Now,
Advocate Nkcukaitobi, isn't it that it is an allegation for now because he is a suspect? No court has pronounced that he killed 13 people.
no, it's common cause that he killed 13 people. The question is whether that killing was murder or not.
Oh,
Yes, but it's
okay.
common cause everywhere. He killed 13 people.
Okay. Well, the question is whether it's murder or it's...
Or self-defense. Yes, but he killed 13 people. He accepts that.
Okay.
I'm simply saying that the NPA, well, not the NPA, the evidence leaders are using that person as the source. That's the only point I wanted to comment on.
Indeed. I'm saying I understand where this background of this thing is coming from, and when suspects would have to be consulted because apparently it's the understanding of the NPA that there's no case against them. So they will probably want to use them to purge the prosecutors at their expense.
Let me understand, Advocate Chauke, before we make a ruling. The source of this document is from Mr. Mostert, who is an accused, or one of the accused, in the Katomena matter.
Yes.
Ordinarily, where will these dockets be? All the dockets, including the Tonto docket.
They will be with the investigation team. In this instance, because the case would have been withdrawn and the charges were withdrawn, they would have been filed back to the various police stations from the IP, then from the investigation team of the DPCI that were investigating the matters. Once the NDPP and the Director of Public Prosecutions have decided that no prosecution should follow.
So, meaning, if I understand you correctly, the relevant police station will be having those dockets.
That's how I understand it, that they would have been filed back at the police stations where they emanated.
Does it then make sense that the NPA went to the station commander KZN to look for this docket,
That's how I understood that. That is where you need to trace them once you want a docket.
but to no avail, as you know.
To no avail. That's how I understood the response from the NPA.
And ultimately, NPA, in its effort to trace this docket, was going to ascertain or to search or to find out from the IPD
Yes.
about the whereabouts of this docket.
Yes.
How does a docket then end with an accused person? Does
To-
it happen?
Yeah, it can happen that the attorney of record who was representing the accused would have been served with the copies of the dockets at disclosure. So probably the accused might have gotten the copies of those dockets from his defense attorney, who disclosure would have been made to.
And in this instance, the evidence leaders whose task is to gather information would have been entitled to receive that document from wherever it was sourced, let's say from Mr. Mostert in this case, as he was made to believe that Mr. Mostert had the document.
Yes. That's how I understand it, that they will be in a position to get it if Mr. Mostert got it from his attorney or from IP and he's having it. He will probably be, when he's asked, will say, I have it, I can provide it.
So given these circumstances, following your answers, it is not unheard of that an evidence leader in the position of Mr. Mutlamuyani would have then received this document from one of the accused persons.
No, not. I think what is problematic now from
No,
whence
just answer the question first.
No.
Then elaborate.
No.
No.
Yes.
And what did you want to say?
I wanted to say in the circumstances where we are, that the NPA and everybody was looking for them, they couldn't get it. It was a concern. But I think bravo that the evidence leader could get it outside of everybody.
But if he consulted with Mr. Boysons, as he did,
Yes.
Mr. Mutlamuyani,
Yes.
and maybe all others
Yes.
who are supposedly lined up for testifying, that will not be unheard of.
Indeed, that's how I understand it.
Counsel, both of you, following my questions and answers by Advocate Chalke, the objection is sustained.
Please,
Thank you,
Madam Chair.
Can I ask you
Before
this?
you proceed, Dr. Mutlamunyane, I want to make it clear and place it on record to both of you. We cannot be sitting here complaining about each and every issue. Let us get to the chase and get to the crux of the matter. It does happen between lawyers that we don't agree about how we address one another, what language, unless it is very, very serious. But if we are seen in a public stage like this, when we are complaining about everything, Dr. Mutlamunyane, let us please try to not to do that. As you know, litigation, we all need to have hard skins and bear with each other. You can discuss these things outside this hearing, and it does happen. We get out of court, you are not happy with what your colleagues did, you go and have coffee. It happens every day. I'm just requesting both of you that Nkcukaitobi. Let me also caution you.
Yes.
I know these issues that we talk about, most of you feel very sensitive about them. but let us try to maintain the decorum that we are all expected to maintain. After all, we are all officers of court. When we emerge out of here, the public will judge all of us in the manner we behave here. So I request you, as senior counsel, to make our task easy and not to make determination on each and every thing. We have substantive applications to adjudicate upon instead of focusing on the real core issue, this inquiry. I request you, and I'm sure I'm speaking on behalf of my sisters, if they wish to say anything before you proceed, they may.
I think it's well said. Thank you, Chair.
Thank you to both of you, Counsel. Dr. Chauke, thank you.
Thank
You may
you, Chair.
proceed, Counsel.
Thank you, Madam Chair. Mr. Chauke, I think this is the right time. I'll still come back to those conclusory paragraphs, but I think the point of the discussion right now requires me to take you to page 70 of that report. 70 at the bottom left. Do you have that?
I'm there, Chair.
Yes. Now, this is the section in the report where there is a discussion on some of the dockets, not all, but some of the dockets. But the context in which the discussion is taking place is in paragraph 191, where they say the prosecution team alleged in the October 2015 memorandum that in their analysis of the modus operandi of the accused, that the tracking or tracing of the suspects for questioning happened without shreds of evidence linking them to any offense. They also allege that the accused also killed civilians and or suspects without any tangible evidence against them and in the absence of warrants of arrest for the suspects. So what they are trying to do is to say, look, your claim that the suspects are killed without linking them to the offenses being committed is unfounded, correct? Accept that.
Yes.
It's in that context that the Maphumulo docket is mentioned. If you look at paragraph 192.1.1, okay?
Yes, the Maphumulo case 99/9/2008.
Yes, now, they say in the docket Maphumulo case 99/9/2008, the murder docket of Superintendent Nkcukaitobi, correct?
Yes.
Now, can I ask you if Mr. Paul Mostert was a suspect in the killing of Mr. Nkcukaitobi?
From the top of my head now, I cannot check. I might have to refer to the indictment to.
No, Mr. Nkcukaitobi's killing is not part of the indictment. Remember, it was the trigger for the killing.
Yeah.
The same as the killing of Mr. Zondi.
Yes.
Yes. Now, I ask you the question again. Is Mr. Paul Mostert an accused in the killing of Mr. Nkcukaitobi?
No.
Exactly the point. Why on earth is he going around with this docket?
I may just suspect that maybe because it's a police or this docket, because it did not form part of the indictments, and they would have access to them in the scope of them being police.
Precisely. That's the only explanation, is that he has access to it in the course and scope of being a police officer.
Yes.
The station doesn't have it, the NPA do not have it. Mr. Paul Mostert, who's not an accused, has it.
I see. Yeah, that's what it is.
Yes. And now you have here a strange scenario. This report is prepared by the NPA, correct?
Yes.
Which means that as of June 2019, they had this docket.
Yes.
Yes. They don't have it now.
From the confirmation that the NPA made, yes.
Yes, well, they told us, Ms. Lekgetho told us they don't have it.
Yes.
And we had a letter from Mr. Anton du Plessis that they don't have it.
The Deputy National Director of Public Prosecutions there.
This is the point, is that they had the docket. in June 2019.
Yes.
So this is the point. How does this thing happen that you have a docket, 4 people are working on it, and then it vanishes?
That's very strange.
But how would this happen? I mean, because the dockets we ended up getting, the 23 that we ended up docket, I know there are many problems with missing information, etc., but they are all sent to us in an electronic form.
Yes, it should follow that if the DCOC panel also considered this case docket, it would have formed part of the ones that would have been on the electronic registers of the electronic storage of the NPA.
Yes, this is why this thing is very difficult to explain, that the NPA, which had it and purports to have analyzed it, doesn't have it. Then someone who's not an accused has it.
The one who's not an accused and
In that docket.
In that docket has it, yes.
Yes. Now, they then talk about a statement that is coming under oath from the witness. They talk about cell phone records. The whole paragraph 192.1.2.3, the whole of that up until 192.1.6, purports to extrapolate information from this docket that is in the possession of Mr. Paul Mostert. Now, you have many alternatives, where perhaps only 2 alternatives. So one is that these people who drafted this report also consulted with Mr. Paul Mostert, and he gave it to them. Or they got it from somewhere else, and then through negligence, they've now lost it.
Yeah, I can accept that because there's no indication that they consulted the witnesses. They consulted the dockets and statements and the like. So I will take it that maybe they worked on it and then somehow it got lost after they've worked on it.
Someone must have given it to them. I'm saying the source could also be Mr. Paul Mostert. It's very difficult to know.
No, it's very difficult to know. I'm taking here on the assumption that the DCOC panel said that they received the case dockets, they received the prosecution memorandum, and they started working on this docket.
But the point is this: the panel still does not have a proper explanation about this docket, because it's not enough for the NPA to say we don't have it, because they once had it.
Yeah, I agree.
Yes. And now it's getting scraps from this docket from Mr. Paul Mostert.
Very unfortunate.
And this is the crucial docket because it's a turning point in the conduct of these Nkcukaitobi police officers when they decided they were going to go on a killing spree.
Indeed, the justification was that all the guys who were supposed to be arrested and they shot at the police, it was because they were suspects in the killing of Superintendent Kon.
Yes. But now we have a scenario where, because we don't have this docket, we can't make head or tail of the summary. Yes. Now, the same thing, is funny. The next case they analyze here is the killing of Ngcukaitobi from paragraph 192.21. 192.2, 192.2.3, 192.2.4. And then they conclude in 192.3. Now, these are the 2 crucial dockets. So this one is called KwaMaphumulo, the killing of Superintendent Konco. This one is called Begitemba, the killing of Nkosizonde. Now, you recall, you've been part of these proceedings, the struggle it took for us to finally get the docket of the killing of Nkosizonde. When we finally got it, we found that it was only 105 pages. So many pages were missing.
Yes, I recall that.
Yes. But we also know now from the evidence of Mr. Mhlongo that these so-called confessions, how they were procured, the 2 that the NPA is relying upon in this report. You see, because look at what they're relying upon. There's somewhere where they're relying, oh yes, at 192.2.3. This information, now this is the information referred to at 192.2.2. about the assassination of Mr. Bongani Mkhize. They're saying this information was later confirmed by Mr. Swayo Mkhize as well as Spam Mhlongo after their respective arrests. So, it says Swayo, but I presume that is Swayo.
Yes.
Yes. Swayo Mkhize made a warning statement, confession, and pointing out the statements of Mkhize implicated the deceased Bongani Mkhize in the conspiracy to kill Zondi. They also identified Sibongile Badumile and Sifiso Ndimande, who were present when they planned to kill Zondi. The motive for the murder was that they believed that Zondi gave the police poison information on the whereabouts of Magojela Ndimande, who was killed in Howick case 106/09/2008. This is the information we went through together with Mr. Mhlongo.
Yes.
Now, when was the Mhlongo trial? 2009?
2009.
Yes. At the end of that year, he was acquitted.
And this civil claim about two years later.
It was settled in 2016. Civil claim was settled in 2016, but
Yes.
the criminal trial was in 2009
Yes.
because he was detained from February 2009. I think he was acquitted in 2010.
Yes.
That record is all public, the judgment of Judge Gianda. There is no attempt here in this report to consider the judgment which acquitted Mr. Mhlongo. There is an affidavit given by Mr. Swayo in which he retracted the so-called confession, which was accepted by the judge in the case of Mhlongo, not referred to at all.
Indeed.
The entire docket that we looked at from Mr. Mhlongo is just not referenced. It's as if it doesn't exist.
Indeed.
Yes. Now, I come back to to really what is the value of this report? It is relying on information which has been discredited for more than 15 years.
Yes, in fact, by 2019, when this report was made, it was made almost 3 years later, not 3 years after the police had settled the claim against them in respect of Mhlongo, and almost 8 years after his acquittal.
Yes. So two crucial documents. One is this affidavit. Now, they're still saying, no, these people were implicated because of the confession by Mr. Swayo. But we know everything about the confession. It was retracted.
Yes.
Then they are also talking about the confessions made by other accused. But we know who those accused are. It's Mr. Mhlongo.
Yes.
And we know what happened to Mr. Mhlongo. Now, you have a scenario where the NPA, I'm not talking even about the police, the NPA is relying on information that has been obtained through torture. Because the authors of this report is Mr. Tikok, Mr. Tenga, Ms. Riley, Mr. Mamabolo. These are senior employees of the NPA.
Yes, in defense of the accused.
Whatever they were trying to do, whether they're doing good or bad, the fact of the matter is that information obtained through torture is unconstitutional. This is what used to happen under apartheid.
Indeed.
Now you have here the 4 senior prosecutors together with the National Director of Public Prosecution. They hoist this report around, but it's relying on information obtained through torture. And they don't tell anyone that there is a trial that declared the information inadmissible.
Very unfortunate.
Yes. You see, which is why they conclude in paragraph 192.3, in both the Congo and the Zondi murders, there was a prima facie case against the suspect. But we don't know anything about Congo because the docket is being hidden from us by Mr. Mostert. We know about Mr. Zondi because we've got some scraps of the docket. But we also know about that case because Mr. Mhlongo bothered to contact me and insist on testifying before this panel so he can tell the truth.
Yes.
Yes. And we know that the source of that information that was used to implicate people there was torture.
Yes.
And this is what they say is the prima facie case.
Very unfortunate.
Yes. Now, then you have their purported analysis after that of paragraph 192.4, Perea. You know what happened in Perea? You've been sitting here. but-
Maybe before you go to that analysis, Advocate Ngcukaitobi, I should ask some questions, put some questions to Advocate Chauke. Advocate Chauke, I'm going to ask once more, I'm sure, about the life of a case docket that ends up at the NPA offices. The origin would have been the police station, am I correct?
Yes.
Then, in the context of this inquiry, it would then land at the DPP's office.
Yes.
And then it would land at the NPA's office,
At national office.
at national office. yeah.
Yes.
Now, what I'd like to know is when you send, and I'm talking about the DPP, sends a docket to the NDPP's office, would the DPP be left with a copy, or what is the position, or would it just go as that original docket moving from one station to the other up to the NDPP?
As a rule of practice, the DPP's office will make copies of the dockets.
So, which means that you would send the original docket to the NDPP without keeping a copy for the Director of Prosecution Station?
In general, if the DPP sends the docket to the national office, he or she will keep copies of that docket in her office.
So, ordinarily, the DPP would keep a copy and send the original to the NDPP. And would there then be, I see you are nodding, is that yes?
Yes.
Right, thank you. Now, would there be a register where there is, checking the trail, where the DPP would have then delivered the dockets to the NDPP and let them sign acknowledgement of receipt, or what is the position?
Yes, there will be a register where somebody will sign for the docket. In most cases, copies of dockets are sent to the NDPP for review. The original will be kept at the DPP's office.
Okay, so it is the copy that would be sent to the NDPP.
Yes.
The DPP would be sitting with the original
Yes.
docket.
Yes.
And that docket would not then obviously be at the police station. It would be sitting in the DPP's office.
Yes.
And once the NDPP makes a decision, taking into consideration that the NDPP would be sitting with a copy, does it become necessary for the NDPP to then return the docket to the DPP, or would the NDPP keep the docket at the NPA offices? What is the norm?
The NDPP, the copies that would have been sent to the NDPP will remain at National Office Archives. Yes.
So, which means at least there would be a likelihood of getting this docket at the archives NPA, if it can be found there, at least at the DPP
Yes.
office.
Yes.
Thank you.
But what I wanted to explain, Chair, is in the context of the general. This prosecution was a poker prosecution, so the prosecution team and the original dockets were all at the national office.
Okay, thank you. So the original, but then because my understanding is that this whole thing starts at the, even if it's racketeering or what, it would have started at the seat of the relevant DPP. Is that the case?
That is the case,
Exactly.
Chair.
Now that DPP would then have to recommend this issuance of the certificate of racketeering.
Yes.
And that DPP would be sitting with the copy, because this is a matter of national imperative or the jurisdiction of the NDPP. The DPP would then send the original docket to the NDPP's office.
Yes, that's why I was saying
Yeah.
that in respect of this, because it was a national project.
Yes,
So
yeah.
the dockets were actually being done from national office. The prosecution team that was now at the time of Advocate Sean Abrams were sitting at national office with these case dockets. So they were not at the DPP, not even at the case at NDPP.
By implication, even those that drew reports like the report presently under consideration would have had access to the original docket.
At
the
national
NPA.
office. Yes,
Thank you.
at national office, not at the DPP's office.
Yes, thank you.
Thank you. I wanted to ask you, Mr. Chauke, about paragraph 192.4. That's the Berea case. Now you look at the summary that's given here. Tabo Sunshine Msimango was arrested on Brighton Beach on a charge of armed robbery. He later escaped from members of the unit and the docket was registered. Now, this is the only thing that is said about Berea. Now, you remember the case of Berea. The gentleman jumped out of the window on the 4th floor. He was shot 3 times by Mr. Mostert.
Yes.
You see. Now, what do you say about this analysis here? I mean, is this any meaningful engagement with what happened in that case?
It's a whitewash.
Yes. Now, assuming that he was wanted for armed robbery, what is the justification of killing him?
There's none at all.
Yes. Then look at what they say then about Melmoth. Now, these are the 4 top officials in the NPA. It's them who are writing this, what we are dealing with here. 192.5, they're talking about Melmoth. Now, Melmoth, you remember, it's the Biela brothers. One of them is naked and is lying on a Rondaville veranda. And the other is younger than him. I think he was 17 years old. Is wearing blue and white shorts and is killed inside a Rondaville. The place is just full of blood.
Yes, that's where there were also shown photos of the police enjoying their drinks outside the homestead.
But there is a thorough report of ballistics by Mr. Mangena.
Yes.
Now look at what they say about this. They say Kanyisani Biela was also killed. According to the police, this person shot at them from one of the Rondavilles through the window. They then moved into the Rondaville and fired 1 round in the direction of the suspect as more shooting erupted. Now, is there any reference here to the reconstruction of the crime scene, which is evidence in the docket?
No.
Yes. Now, you see, on this point, I asked Advocate Batoy in relation to the killing of Kwazindlovu, why her letter to the mother of the child did not refer, well, the mother through
Mary
DeHaas, yes, did not refer to the evidence of the expert. She says it's because it was not in the docket. She never knew that it was there. It was, in fact, the first time in this inquiry that Advocate Batoy became aware that there was a report by Mr. Mangen. Now, this is the full extent of the analysis, this paragraph I've read to you. I mean, what do you say about this? And it also just doesn't make any references to all of the evidence pointing to the guilt of the accused.
No, it's a whitewash. And the last sentence there in that paragraph, 192.5, which says they then moved to the Rondaville and fired 1 round in the direction of the suspect as more shooting erupted.
Yes, I mean, this is a killing in the early hours of the morning. And the gentleman is naked. I mean, it's truly, truly bizarre. Then they talk about Phoenix. That's the killing of Mr. Nzuza. And then they say, well, he's wanted on various That's the only thing that is said here. There is nothing mentioned about whether the killing by the police was justified. I think this was also a Mostert special. Nothing at all in paragraph 192.6, which explains why the killing was justified. It just says, well, he was wanted on various offenses.
Indeed, one would be interested to hear the part of the authors of this report to say why the analysis of ballistic reports and the actual statement of the police were not analyzed as against the ballistic reports.
And then the same thing with Kwamashu 192.7. They here talk about, this is now the killing of Mr. Tabede, who was also known as Mtago. Then all the thing that is said here is that there was a reliable source that implicated him in a statement dated 26/11/2009. But again, nothing about why was the killing justified.
It's my proper reading of the analysis here. It moved on the assumption that all the killings by the police were justified. So all they need to do was to identify who has been killed and what. That is what the report is doing.
Yes, but the report is meant to show why your team, well, not your team, it was Mr. Mayema's team, but why the prosecution team was wrong in preferring the charges of racketeering, which include being in the racket and committing the predicates. That's what it's meant to do. And what you get is this, that there was a reliable source, no information about this reliable source, no information about how this reliable source linked, and no information about why the execution of this gentleman was justified.
Yes, Chair, even if there was a reliable source and indeed they killed those people, but still they had to be arrested.
Yes.
The report, if you remember the paragraph 176 in relation to what they say, 167 rather,
Yes.
that there was no evidence.
Yes.
You can see with the summaries that you're referring us to, it seeks to corroborate that very statement, because when you read this paragraph, the summaries, they can only seek to corroborate paragraph 167, to say there was no evidence. Am I correct?
You are correct, Chair.
Advocate Chauke?
You are correct, Chair.
Yes. Thank you, Madam Chair. And then you look at probably one of the saddest, although one doesn't want to compare death. Death is death. It's as bad for an 18-year-old and it's as bad as for a 6-year-old. So maybe that's a wrong statement. But then you look at the killing of of the young man, KwaZindlovu, at how it is dealt with by these 4 senior prosecutors, 192.8. In Eskawini, look, there are also many spelling errors in this report. You know, people's names are misspelled, places' names are misspelled, the dockets' names are misspelled. It also just shows it was a bit of they just didn't care what they were doing, you know. So many errors, you know. Like now they can't spell Eskawini. They say Esikwanini.
I see that, Chair.
But yeah, you can do the same thing. You'll find so many errors in this report. The deceased was Kwazi Ndlovu. The police were investigating the matter related to Westfield, case 263-210, in which 9 prisoners escaped from Westfield Prison, Medium A, 7th floor, and then they give a date. They were following up on information of the suspect, Dilili Mzimela, who escaped from Westfield. On their arrival at house number J63, they introduced themselves as the police and they entered the house. The deceased was killed. Mzimela later on made a statement in which he states that his family rented out the property to the Ndlovu family. Again, there's just no analysis here.
Yes, there's no analysis. If I remember well, Advocate Shamila Batoe, when she testified, she said she accepted all the decisions except for this one, where the matter was referred to trial and the accused, Padayash, was acquitted.
Yes, I understand, but I'm talking about the report itself, that the report is so bad that it does not address the fact that this was a young boy that was sleeping on a couch watching television. And old men from the police force came with rifles and executed him in cold blood fashion.
Yes, and they claimed that he was pointing a gun at them.
And
And
after
in
that,
his
they
sleep.
planted a gun. Yes. After having shot him with an R5. And this is all you get from 4 very, very, very senior prosecutors.
Very unfortunate, especially for this young boy who was killed in that fashion. Very unfortunate.
Yes, but what is it saying about the competencies that reside in the NPA? The NPA is a constitutional office. The people that are employed there are meant to do better than what they have done here.
Oh, you can Google even this report. You'll see how it's highly celebrated it has been for the past years.
When you say 4 senior prosecutors, you say it on the assumption that the report was unanimous,
Yes. Let me say 2. Yes.
or 1.
Or 1. Thank you, Madam Chair. That's a big mistake.
I have a follow-up,
Contradicting myself.
especially on this matter in 192.8. There was later a statement by Mzimela. I'm not sure who Mzimela is, but I think even in testimony we were by, was it Advocate Maema or the ballistic, who flighted a picture of the area and showed us that the Ndlovu family had rented a house, a property nearby, because they were renovating their house.
Yes.
Which, I mean, common sense would then say or bring one to the conclusion that this was a question of mistaken identity, because they went into this house looking for a specific person. They were looking for Tilili Mzimela.
Yes.
Yes.
And the Mzimelas were not in that house. So
Yes.
it was then Ndlovus who were in the house. And a family member of the Ndlovus was killed.
Yes.
Was there, as far as you know, so my question would be twofold. Was there, as far as you know, an apology that was tendered to the Ndlovu family on behalf of SAPS? Or, as a prosecutor, does it ever happen where a mistake such as this one has occurred, where you would apologize or show remorse or talk to the family and explain to the family what happened?
In most instances, if something like this happens, you consult and update the families and bring them up to speed about what is happening in the process. Indicate your position as the NPA, as the prosecutor, to say this is what has happened. This is the resultant of this, and where necessary, tender an apology, especially in the sense where you would have realized that the prosecutor has got it completely wrong.
Did any of that happen in this instance?
Not that I'm aware of, Chair.
Thank you, Madam Baloima. In fact, Mr. Chauke, the NDPP, the most senior person, came here and said, well, we prosecuted the case, there was an acquittal. And when I asked her, why are you singling out this case? And she couldn't give me a straight answer. It seems that it was vindication for them, that there was no evidence. That's why there was an acquittal.
That's how I understood the evidence from Advocate Batu.
Yes. What she couldn't explain is why the evidence of Mr. Mangena was not used in the trial when he was available and willing to testify?
Unfortunately, the people who did the prosecution and that who submitted the reports to her, they failed her in that regard, because they should have made sure that they provide her with all the information in respect of that matter.
So I don't understand that. The letter was written by Mr. Haas to her.
Yes.
She wrote in her own name, justifying the decisions made by the prosecutors in that case. And when I asked her here, why was the evidence of Mr. Mangena not used, she couldn't explain. So why are you saying she was failed by someone else? That was her own decision.
I'm saying this because we heard from the evidence that she asked for a report that came to her to explain what happened at the trial, which was forwarded to her by Advocate Msinyat, who had received it from the DPP of KZN, who had received the report of the Advocate Sangar,
Yes.
cannot remember, who did the actual prosecution, and who would have provided the reasons why that evidence was not considered. And it's in that context that I'm saying that.
No, but you see, I would have expected that if you have a complaint from a member of the public, in fact, this is not a member of the public, this is the mother of the child,
Yes.
you would at least say, well, just give me the documents of this particular case, I want to look at them. You wouldn't look at one memorandum.
That's unfortunate. It's unfortunate, and given the history and the high profile of the matter and the decisions that she made then, one would have said she needed to go an extra mile, especially in the context of what the case involved.
Yes, I understand. But what I also couldn't work out there is why she learned here when she was being cross-examined that there was in fact a report of Captain Mangena.
That I understood that she considered that she did not read, and she does not read some of the things. I think that surprise came to her that's why she was surprised when she was sitting.
Not some of the things. He said she does not read the dockets.
Yes, yes, Chair.
But it also looks, Advocate Chauke, that it's not only her, it's also these authors of this report, because there is no engagement with that report here.
I agree.
Yes, this is what I really am perplexed by, and this is really an honest question. But how does the NPA actually work? Because the country entrusts so much responsibility on this institution. So no one reads the dockets, dockets go missing, decisions are just made without any assessment of the pros and the cons.
Very unfortunate, but the reality for me sitting here, this does not define the whole of the NPA in terms of how they do the work. Unfortunately, in this instance, this was done for all ulterior motives and whatever. It couldn't be. That the NPA as an organization will be described by this conduct of what happened in this specific report.
Yes, and then there's also Mr. Gwala that's referenced at 192.9 in the second Eskawini case, which again is spelled as Esikwanini. Then they're also talking about someone who went to do a pointing out. I can't remember whether this is the gentleman that they went to his house and they took him from a meeting, a community meeting, and they took him to his house, and they murdered him inside the house.
I think that is the one, because there were two
Yes.
Estikawini
Yes.
incidents in the indictment.
Yes. Now, but again, we only have 5 lines here which don't tell us anything about why this murder, this killing rather, would have been justified, even under Standing Order 251 or under Section 49(2) of the Criminal Procedure Act.
Indeed, there's nothing.
Yes. And then they say, well, this deceased had a pending case of an illegal firearm. I just don't understand. And then the police found a pump-action firearm lying between the mattress and the base. But we again know the story of these firearms, how they end up there. We have at least 3 eyewitnesses who saw the police planting the firearms.
Yes.
Yes. Oh, yes, in fact, I'm corrected on this one, that even this narrative is actually wrong, that this is Mr. Gwala who was wanted. Yes, I remember this case. This is exactly the one. This is the one they took someone from a community meeting.
Yes.
And they were looking for somebody called Bar.
Yes.
And this is not the guy called Bar.
Yes.
But they killed him.
Yes.
Yes. They don't even reflect that story here in this report.
Yes, like I said, once you do a whitewash thing, the thing that will dispel your intended conclusion, you will never mention them.
Yes.
Like it has been pointed out, once they started to say there is no evidence, so you couldn't, when you make an assessment, go and find evidence which contradicts your finding already that there's no evidence.
Yes, but at the very least, you would expect there will be honesty to the facts, even if you reason them away. There would be honesty in recording the facts accurately. And you would expect this from the NPA.
Yes, that is the expectation. But unfortunately, in this instance, because it was a whitewash, the facts, if you consider them, they will contradict. Just considering the facts without doing anything more, they will contradict the notion that there's no evidence.
Yes. Then there is then the second last case, 192.12. It's the same gentleman. There are several matters against him. Eskawini case 423, Eskawini case 196, Eskawini case 484, and more and more and more. Attempted murder, and attempted murder. Now, when I looked at this, it seems that what the modus operandi, in fact, it's similar to what Mr. Boysen wrote in his book, when he said that in relation to the killing of Mr. Bongani Mkhize, the gentleman who was driving a black Lexus. He says, well, the beans were spilled by Swayo. That's how he met his death. It says if there's somebody who makes a confession against you, you can just be killed.
Very unfortunate.
Yes. And that's the kind of picture they were trying to create here against the deceased in the second discovery, Mr. Gwala.
Yes.
Who, in fact, they mistook from someone else.
Unfortunately, like I'm saying, if you look, the summaries here, which are done here, is to indicate that all these people were shooting at the police, and the police were justified to kill them.
But there is nothing here that says they were shooting at the police. Not a single one in the summaries.
No, in the opening of where they start dealing with the summaries, that's how I understood that they were saying that the suspects were killed once they were trying to shoot back at the police.
Yes, I thought that the only thing they said was that they were sought for offenses. If you look at paragraph 192.2.
No, I take it. I think I was reading from their assessment of the indictment, yeah.
Yes, so the only thing here that is that they are sought for offenses, but there is no analysis of the justification of the killing.
Yes.
Which you would expect, because Standing Order 251 says if the police has killed, it's up to the police to justify.
Yes.
And Section 49, subsection 2 says that if you overuse force, you become the aggressor.
Yes.
Now, So that takes us to Mr. Gwala. Then the next one is Mr. Majola in escort. This is one of the gentlemen sought for so-called ATM bombings. You know, one of them is the one was found in a rubbish bin and then shot from the top there.
Yes, I remember that incident.
Yes. Now, again, the only thing that is said is that, well, he is a suspect in an ATM bombing. But who decides whether he should meet his maker or not? I mean, no one. The Constitution says no one, the state has no power to kill because of the right to life. But the police here and the NPA in particular, which worries me greatly, is that they seem to suggest that these people are sought for offenses and therefore the killing is justified.
Very unfortunate.
And then paragraph 193, this analysis clearly shows that all of the deceased either had cases pending or were being sought in connection with cases in order to be questioned or charged, and that the averment that the police traced or tracked the deceased without there being a shred of evidence against them is misleading. Now, it's very unclear why they say this. They have just analyzed the case of KwaZulu, which is the most glaring one. They have also just analyzed the case of Bar, also another glaring one, where these people had nothing to do with what was being sought.
Yes, as I say, once you start from the premise that there is no evidence, what follows thereafter should stick to what you have already concluded.
Yes. Now, then they have an issue with what they call killing of innocent civilians, which the police alleged were suspects. And then they talk about Kanyisani Biela and KwaZulu. And then they try to analyze that in 195 and 196. And then in 197, they say that in relation to the latter, and that's now KwaZulu, we are of the opinion that the investigation should be concluded and a decision be made whether Padayache should be charged.
Yes.
But the other 17-year-old boy, they don't make a similar conclusion. That is Kanyisani Biela.
Yes.
Because they're talking about cartridges found in the Rondaville. But there's still no engagement with the expert report that reconstructed both of these scenes.
In the report, it's not there.
Yes. And you know, that then ends the analysis of the dockets. You go through this, you don't find any analysis of the dockets. Then you get at page 82, lack of proper investigation. One paragraph you find also just stuck in arbitrarily is the paragraph 200 that is talking about, you remember the lady, Miss Denise Harley, who witnessed the police planting a firearm. You know how she's that criticized in this report? It says there are, however, contradictions between her first and second statement she deposed to, and between her statements and that of the two accused who were arrested before the deceased, Nkabinde and Ngcukaitobi. Now, they allege, they are now explaining the so-called contradiction. They allege that it was Mostert who came to look for the firearm in the quantum vehicle in which they were seated. A21 saw Mostert take out a .38 from under the seat. A22 overheard Mostert, this is now Paul Mostert who's killed 13 people, asking the other police officers for his spook. It appears like highly unlikely that Mostert would do this in front of the co-accused of the deceased. It also appears that Harley changed her version of the events to fit in with theirs. Initially, she said that the white male instructed the Indian male to shoot. She never said she saw him leaving and then returning. She also pertinently said Mostert came in afterwards and asked what happened. She never said he came in with the firearm and placed it in the room. in her 2012 statement, she refers to more than two white males who went into the bedroom and placed the firearm there. Now, that's the only analysis that is made. Now, the only eyewitness was there. You remember what happened to her? They put a blanket over her head, and then they killed the husband, and then they removed it.
Yes.
And then she says after they had removed it, she saw them putting a firearm. And now the prosecutors spent 3 paragraphs looking at her statement. But if you excluded her statement altogether, you would still be left with the analysis, the ballistics analysis.
Which corroborates that the deceased did not have a firearm.
Yes. But the way that this analysis is taking place is like, well, just attack the victims.
Yeah, in this instance, you see contrasting view between those who wanted to prosecute and those who did not want the prosecution to ensue.
Yes, but I mean, let us assume that you have because what's also strange about this, when you go to those statements, is that actually she never changes her basic view that she saw them planting a firearm. It just never changes. She does change about how many people walked in and out, etc. But this is in the middle of the night. She has been blindfolded effectively, and she is too traumatized because they've just killed her husband.
But it's also immaterial how many people went in there. If the people who went there to shoot, they themselves, they said they shot.
They admit
so
that
whether they are 4, 10, or 15, it's neither here nor there.
Yeah, so those contradictions will be immaterial.
Of course.
Yes, I see. So that's your point, that actually these contradictions they're talking about are irrelevant to the decision of whether there is a prima facie case.
Indeed.
Yes. Yes, so I came back then to this point that thereafter you don't find any assessment of these dockets. You see. Then you come to the section, page 86, where there is an attempt to deal with the ballistics report. Now, I'll show you something here about the ballistics, which we dealt with in full. The first thing is that Mr. Mangena gave us 23 ballistics reports. What you don't find here is an analysis of those reports. Mr. Stale, I think, gave us 10. Again, you don't find an analysis of Mr. Stale's reports. Can you say it yourself?
No, in fact, now that I'm looking at it closer, I'm just surprised that if they say ballistic evidence and then there is referring to LCR and the like, I'm just concerned that maybe the interpretation and the analysis of ballistic is the understanding is not the same.
I'm not sure I understand. I'm saying between paragraph 220 and paragraph 227 is where they are addressing ballistics. The ballistics that the NPA was relying on is Mr. Stale and Mr. Mangena. Mr. Mangena having produced 23 reports and Mr. Stale having produced 10 reports. These paragraphs don't refer to any of those.
Yes, I see that. That's why I'm saying
Yes.
I'm surprised that the heading is there's ballistic evidence, but the actual ballistic evidence of Stale and Mangena is not what is being summarized.
Yes. And then in paragraph 221, they...
Council, before, sorry to interpose, paragraph 205. Do you understand what it means? If you may read it into the record first.
These allegations should be evaluated against the totality of the evidence in the docket. There is evidence in many dockets of prima facie residue found on the hands of the deceased.
Do you understand what they mean?
They are conveying to say most of the deceased in their hands there was primary residue of the firearms that were found with them.
Do you understand what the first sentence means? These allegations should be evaluated against the totality of the evidence in the docket.
Yes,
What does that mean?
I understand the allegations against the police. Yes. So the allegations that the prosecution team are making against the police should be evaluated against the totality of the evidence in the docket.
Do you understand what that means? In practical terms?
No, in practical terms, Madam, I don't necessarily follow.
Doesn't it mean that, and correct me if I'm wrong, doesn't it mean that these summaries that they have provided which seems to be in favor of the accused persons should be evaluated against the totality of the evidence that is contained in those very dockets that they are summarizing?
Yes.
Now, if that is the case, could they have come to the conclusions they have come?
I don't think so. If the totality of the evidence, as they say, is what is contained in the dockets, then the conclusion should completely be different.
The converse should be true.
Indeed, Chair.
As a follow-up, maybe the question should be, when this report was compiled, did the 4 prosecutors have all the dockets in front of them? And also, did the dockets have all the necessary evidence that is supposed to be in the docket? For example, the NDPP, the Advocate Batohi testified that she was seeing Captain Mangena's ballistic report for the first time. So I'm asking this question, and that doesn't that mean that these 4 prosecutors should have had all the dockets in front of them, and the dockets containing all the necessary evidence inside?
That is correct, because when, remember, Advocate Maema and Matenja, they were sitting at national office in the NDPP's office with all these dockets. So the assumption will be when this team was appointed to have a look in those dockets, they would have a look on those dockets that would have been in the custody and possession of Advocate Maema and the prosecution team.
And so, in conclusion and in responding to the chairperson's question, you said they would have come to a different conclusion.
Indeed.
Thank you.
Thank you. Now, I took you to the ballistic section, and I've showed you there that in the section where they must be dealing with ballistics, Mr. Mangena and Mr. Stale are not mentioned, correct?
Yes.
Now, then they make passive appearances. Firstly, at paragraph 208. 208, page 81, Madam Chair. Now, they say here, In an attempt to counter the defense that the deceased fired at them and were in possession of firearms, statements were obtained from experts such as Stale, Captain Mangena, and Dr. Reggie Perumal. Stale was initially appointed as the defense's expert in some of the dockets. Can you just comment on that? Why is this an important fact that they must mention?
Because Stale was appointed by Hlapane attorneys on behalf of the families of Mkhize and others.
Yes, but why does that matter? That's what I'm asking.
The impartiality or otherwise of the report of Stale is being put into question.
But why? He's an expert. He's an expert. I don't understand.
That it was because of the attorneys. It was not by the state. That's how I read.
But that's what I don't understand. An expert is an expert, period. And there are rules of expert evidence. Whether you are called by me or called by my opponent, if you are an expert, you are there to assist the court. So when Mr. Mangena was here, he's not here as Mr. Chauke's witness. He's an expert. He's there to assist the panel.
The prosecutor in me says when an expert is procured by the defense, I'm reluctant to consider it because it's coming from the defense. That's how it happens in practice.
No, I'm not sure I understand. An expert is meant to assist the court. So I bring an expert or you bring an expert. He will assist both of us because
Yes.
he will make concessions where it's fair, but he will be neutral.
Yes, I'm saying you're asking me to comment why the prosecutors are saying that here. No.
So you are trying to interpret what they are saying.
Yes.
No, but I'm asking you, why does it matter?
It doesn't matter.
Okay. Now, then he says in 2012 he was appointed to do reconstructions of some of the crime scenes and is now to be called as the prosecution's witness. Now, of course, the problem here is that they don't mention that Stale was there in 2008 when Mr. Mkhize was killed. All of these experts relied on crime scene photographs, post-mortem photographs, and other statements in the docket. Their evidence should be evaluated against the evidence of the pathologists and ballistics experts that examined the bodies of the deceased and exhibits. I presume that is a fair statement.
It's a fair statement, but it contradicts their conclusion.
Well, the problem is they never engage with it.
Indeed.
You know, they never engage with, these are the findings of Mr. Stale, and this is why they are wrong.
Yes.
Yes. And they are also not telling the truth about what they relied upon, because Mr. Mangena primarily relied on being present at the crime scenes. The idea that they were so distant, they say it was photographs, post-mortem photographs, and other statements in the docket. But Mr. Mangena's evidence was that he visited the crime scenes himself.
Yes.
He didn't just sit in an office and then rely on statements in the docket.
Yes.
And Mr. Mangena's evidence was that he spoke to some of the witnesses. Yes.
And in respect of Stale, he actually attended the physical bodies when the postmortems were being conducted.
Yes. Now then, in paragraph 211, the experts come back again. In Mandini case 7609-2008, the high watermark of Stale's statement is that he alleged that the police fired at the suspects when they were already in a lying position. He says that the deceased Mzamani Johannes Nduli death register sustained multiple gunshot wounds. The police officer concerned is not denying that he shot at the accused while they were lying. According to Naidu, as they entered the room, a black male alighted from the cupboard armed with a pistol. Stores fired a shot. Naidu fired several shots towards the suspect. The suspects fell to the floor. The suspect still had the pistol in his hand, and Naidu continued to fire at the male. Now, again, this is just an acceptance of the entire police version, and it's not tested against any logic and against any crime scene reconstruction.
But the summary of that paragraph at the end of it says directly the opposite, that then there is a prima facie case then which the accused must reply to.
I'm saying your conclusion from what they have written
Yes.
is that it simply shows that Naidu should have been charged.
Yes.
Yes, I see. Then the last paragraph where the experts come back to the scene. is paragraph 224. And that's the Mundane case, where it says the ballistic investigation is also incomplete. Several of the cartridges, bullet heads, and fragments found on the crime scene are not linked to any firearms. It appears that the firearms of the police were not seized at the time and sent for ballistic testing and comparison. The ballistic expert Stale, appointed by IPID. Now, was Stale ever appointed by IPID?
Yes, I think in